Rule 4.2 Rule 4.2 Service of Process Fed. RCiV. P4 provides for alternative methods of serving the summons and complaint in a civil action. Methods established by the rule itself are preferred, particularly Rule 4.d. Waiver of service, duty to save costs of service, request to waive, and should be attempted before service is attempted pursuant to the Ohio mail methods authorized by Fed. RCiV. P4.E.1. Fed. RCiV. P4.E.1. Authorizes service pursuant to the law of the state in which the district court is located for a summons or other like process upon the defendant in an action brought in the courts of general jurisdiction of Ohio. Rules 4.1 and 4.3b of the Ohio Rules of Civil Procedure provides for service by the clerk mailing the summons and complaint by certified mail. An attorney who attempts to effect service in this court pursuant to the law of Ohio must comply with the following procedure. A plaintiff's attorney shall address the envelope to the person to be served, shall enter as the return address the address of the issuing location for the office of the clerk, and shall place a copy of the summons and complaint or other document to be served in the envelope. Plaintiff's attorney shall also affix to the back of the envelope the domestic return receipt card, PS Form 3811, July, 1983, the green card, showing the name of sender as clerk, United States District Court, Northern District of Ohio at the appropriate address with the certified mail number affixed to the front of the envelope. The instructions to the delivering postal employee shall require the employee to show to whom delivered, date of delivery, and address where delivered. Plaintiff's attorney shall affix adequate postage to the envelope and deliver it to the clerk who shall cause it to be mailed. The envelope should be unsealed when it is delivered to the clerk so that the clerk can verify the contents prior to mailing. B. The clerk shall enter the fact of mailing on the appearance docket and make a similar entry when the return receipt is received. If the envelope is returned with an endorsement showing failure of delivery, the clerk should forthwith electronically file a return of service unexecuted which shall serve as notice to the attorney of record, or if there is no attorney of record, the party at whose instance process was issued, who shall be copied by regular mail, that service was not obtained. C. If service of process is refused or was unclaimed, the clerk shall forthwith electronically file a return of service unexecuted which shall serve as notice to the attorney of record, or if there is no attorney of record, the party at whose instance process was issued, who shall be copied by regular mail, that service was not obtained. If the attorney, or serving party, after notification by the clerk, files with the clerk a written request for ordinary mail service, and submits to the clerk an envelope containing the summons and complaint or other document to be served, with adequate postage affixed to the envelope, the clerk shall send the envelope to the defendant at the address set forth in the caption of the complaint, or at the address set forth in written instructions to the clerk. The attorney or party at whose instance the mailing is sent shall also prepare for the clerk's use a certificate of mailing which shall be signed by the clerk or a deputy clerk and filed at the time of mailing. The attorney or party at whose instance the mailing is sent shall also endorse the answer day, 2,428 days after the date of mailing shown on the certificate of mailing, on the summons sent by ordinary mail. If the ordinary mail is returned undelivered, the clerk shall forthwith notify the attorney, or serving party, by mail. The attorney of record or the serving party shall be responsible for determining if service has been made under the provisions of Rule 4 of the Ohio Rules of Civil Procedure and this local rule. This local rule is confined to the domestic service of the summons and complaint in a civil action in this court by certified mail or ordinary mail, pursuant to the law of Ohio, and is not intended to affect the procedure for other methods of service permitted by the Fed. RCiV. P or the Ohio Rules of Civil Procedure. Effective 2.